Hello, everyone, and thank you for joining me today. My name is Deontay J. Marquis, and today I will be presenting to you on the topic of federal laws concerning assisted living and long-term care facilities. And this presentation is brought to you, of course, by my alftraining.com. So today we will begin our presentation. So our course objectives are a little general today. We're going to specifically be discussing the origin and implications of laws that were created throughout American history that impacted, as we said, assisted living facilities, long-term care facilities, patients and employees as well. So we're going to specifically talk about what those implications were, how some of those federal laws came to be, and their effect on both employees and patients in those two healthcare settings. So, um, as you can see here, the first is going to be Americans with Disabilities Act, commonly referred to as the ADA Act. Next, we're going to move on to the Civil Rights Act of 1991. After that, we will be discussing the Rehabilitation Act of 1993 and also the Family and Medical Leave Act of 1993. So in 1993, the federal laws affecting us in our workplace and the patients as well. Um, there was a lot of debate going on in that particular year. And last but not least, we will be discussing the Fair Housing Act. And after we go over each of these five federal laws and their impact, we will have a short quiz just to test your knowledge and make sure that you were paying attention and took away all of the information that we outline here and that is also expected to complete this presentation. So let's begin now. So first, we will be discussing the Americans with Disabilities Act. So what is the Americans with Disabilities Act? Well, we know by the title two things, of course, that it's going to be talking about us as Americans and also focusing on a particular population within America, those who have been deemed to have a disability. So the Americans with Disabilities Act is a civil rights law that specifically prohibits discrimination against individuals with disabilities in all areas of public life. So, all areas of public life, the ADA specifically prohibits discrimination against them, whether they're at work, at school, using public transportation, or private places that are open to the general public. So, what was the purpose of them passing this law? Because this is something that we want to understand what's the reasoning behind passing this specific law in society. And that purpose was to make sure that everyone that had a disability or didn't have a disability, but specifically those with a disability, were treated equal. And so individuals with disabilities, they found that they didn't have the same rights or opportunities as everyone else. And so the ADA Act, it gave civil right protections to the population of people that was at risk, so those people with disabilities, and it guaranteed them equal opportunity as their counterparts in society or the people without a disability. So it's a very important landmark in history. So, some specifics about the Americans with Disabilities Act, the ADA Act. It applies to employers with 15 or more employees. So remember on the previous slide, we talked about how it affects public places of employment, jobs, schools. So if the employer has 15 or more employees, then the ADA act specifically, they have the employment employers have to abide by this law. Um, this law prohibits those employers from using disability as a basis for discriminating against qualified individuals. So what does that second bullet point mean? Well, employers can't use an individual's disability as a reason to not offer them a position or to offer them a promotion if they're already employed. They have to make sure that the individual who has the disability has the same opportunity as individuals who don't to perform that job task if they are qualified, which would mean that they also have to provide reasonable accommodations for that individual with disability to have the opportunity to perform the job functions. Again, of course, they have to be qualified to do so. Now, everyone with a medical condition is not protected by the ADA, contrary to what some may believe. Everyone with a medical condition is not considered to have a disability. Um, Only those individuals who have been found to have a disability. And now that last two statements may leave you confused. Well, how do they decide who has a disability if someone has a medical condition? What is the line between a medical condition and a person with a disability? So I have here the specific language on how in the Americans with Disabilities Act, they come to identify the difference between a person with a medical condition and a person with a disability. So there are three key components to this definition that define someone with a disability. Now, the first component is they define a person with a disability as a physical or mental condition with substantial limits to their common life activities. So, what are some common life activities that you or I or anyone participates in every day? Well, very simple things. I have them listed here: walking, talking, thinking, breathing. All of these are common life activities, which, if a person's physical or mental condition limits substantially their ability to perform these activities, then their medical condition can be defined as a disability, as according to the Americans with Disabilities Act. Second, a history of disease or disability. So, again, a person whose medical condition limits one of these common life activities can be their medical condition can then be defined as a disability. And the second part of this definition is, let's say a person has a history of a medical condition that was defined as a disability, but as we see here in the examples I provided, somebody with a leg amputation or cancer that's in remission now, they don't still have the condition, but they have a history of the disability. Can it still be defined as a disability under the ADA? The answer is yes. So just to put some more clarification on that second part of this definition, let's say a person had their leg amputated. We know, or you may or may not know, it takes a while for someone to learn to walk or to learn uh, to use their prosthetic or get everything they need together for rehab, or if they're going to be using a wheelchair, to be able to get their mobility back by themselves. So during that phase, of course, they will fall under the first part of this definition, because a serious life condition, medical condition, has limited one of their common life activities. But once they've overcame that first few months or years in learning to use their prosthetic or getting all their medical devices together to rectify or regain their mobility, then it comes to be known as a history of disease or disability. And this is still classified as or under the Americans with Disabilities Act as a disability. And third, although we have it listed as number one, a physical or mental condition that is not transitory. What does that mean? Transitory. Transitory, I have it specified there, lasting only a specified time, which is usually 6 months or less. So let's say our our employee fell and broke their leg, and the doctor says that they have to be in a cast for the next 5 months. Well, that would be defined as a transitory condition, which means it's something that they can transition from. It's a transitional disease. It's not permanent. After the 5 months, they'll take their cast off and they will be um, back to non-disability. Uh, they'll be they won't have a disability anymore. They'll be back to normal. Everything will be fine. They'll be walking, easily performing the common life activities that we have listed at the top bullet point here. So, if we were so we were trying to define between a medical condition and a person with a disability, where is that line drawn? So we talked about on this slide, that line is drawn when the person can or cannot substantially perform these common life activities. If they have a history of not being able to perform these common life activities, or if their condition is not transitory. So it's not transitory, something that's not permanent. So we could say someone has pneumonia on and off for 3 months, or sickle cell that, no, that wouldn't be a good example. Well, let's use the pneumonia. So they have pneumonia on and off, they can't get rid of it. It's not transitory. The effects of the pneumonia would have a serious effect on their ability to breathe, one of our common life activities. But after the pneumonia finally passed, and they took all their medicine and their treatment, their breathing treatments, they would regain that ability to perform that common life task of breathing. So that would be a transitory medical condition and not qualify them to have a disability. So moving on, Americans with Disabilities Act. The ADA calls for individuals with disabilities to have access to jobs, appropriate public accommodations, government services, everything that people without disabilities have access to. The ADA wants these same rights and opportunities available to individuals who do have disabilities. So, what the ADA Act is calling for is that individuals with disabilities need access and opportunity to all aspects of society that is available to those without disabilities, which may limit their access. So, the law specifically is comprised of 5 titles or statutes or chapters, if you will, that outline the specifics of what the American with Disabilities Act is hoping to acquire for these individuals in society who have disabilities. Now, there are 2 specific titles that apply specifically to healthcare facilities such as nursing homes or assisted living facilities, daycare centers, what have you. There are 2 specific titles that have language specific to us. So those are titles 2 and 3 of the 5 titles in the ADA Act. Now, of course, you're probably wondering, what do those 2 titles talk about? What do they say? Well, Title 2 refers to state and local governments and includes organizations that provide service on the state or local government's behalf, such as a state hospital or a city clinic or a state clinic, regardless of the receipt of federal funding. So, whether or not a facility receives federal funding, Title II says that if they're operating on behalf of a state or local government, then they must abide by the ADA. So that's what Title II specifically says. So I'm pretty sure that covers a lot of um, state hospitals, university hospitals, clinics, public clinics. Um, so a lot of facilities are covered there. Now, Title III refers to all places of public accommodation, regardless of whether they receive federal funding. And these are places that where individuals inside the public can get goods or services, doctor's office, hospitals, clinic, nursing homes, etc. Those are all those places. So they provide a service to the public, regardless of their federal funding received. So how do these two titles apply to you specifically? Well, it says it's telling you should be telling you that you and your facility are required to ensure that health services are fully accessible and equally provided to individuals, whether they have a disability or not. And whether they have a disability or not, both parties should receive full and equal access to care. And any physical barriers which may limit that access for individuals who have a disability should be adjusted, accounted for, or changed so that, again, each party has full and equal access to the care. And if not, then changes need to be made to the policies, to the practice, or any procedures within the facility to make sure that all parties have full and equal access to care, regardless of physical barriers. So, this was one of the more wordy of the federal laws of the five that we're going to review today. So I wanted to make sure I put some examples in here just to further illustrate and drive home the points and the message, the main theme or message of the ADA Act. So an example here we have elderly residents of a nursing home may have trouble reading signs from a distance. The ADA outlines specific standards for various elements of ADA signs for them to be readable for visually impaired people. To accommodate all residents with or without this disability, the facility should. So I'm gonna read to you some examples of what the facility should do to be in a line with the ADA Act to make sure that this there are no physical barriers limiting the care or the services available to an individual, regardless of whether they have trouble seeing or not. They should implement high contrast between the backgrounds and characters on the signs so they are easily read by people who have vision problems. And there are specific ADA recommendations that call for specific typefaces, such as sans serif or simple serif fonts with medium weight that can that can help assist those individuals who have vision problems to be able to see these signs from a distance. The facilities also make sure that those signs are mounted at the correct height, placed above doorways, areas where all individuals can easily visualize the information that's being posted there. And the facility is then making itself equal to people who can see the signs very easily and people who can't. So it's equal and full access to services and opportunities, making each of the different person, regardless of their physical barrier, feel like they're at home. Um, and last but not least, make sure that they're using signs with characters and backgrounds that don't create any glare. So just really paying attention, going the extra step, and making sure that all the signs are easily visible and readable for individuals who may be visually impaired. And now another example of the ADA Act. Um, at play would be in this example here. So let's read this together. Uh, Many residents at a nursing home or assisted living facility may be ambulatory to varying degrees. Therefore, depending on their disability, they will require the assistance of a cane or crutch, while others may need walkers or wheelchairs. To make sure that all residents are accommodated, all spaces used by them, both inside and outside, should have what of the following to make sure that equal accommodation is available to all residents, regardless of their mobility status or the tools that they may need to help get them around. So, this facility should make sure that all spaces in the facility, furnishings and equipment, windows, everything is operable and easily reachable to patients or residents who are using crutches or canes or a wheelchair. So they need to make sure that they have equipped all of the doors and windows and furnishings to be available to from a standing height or from a sitting height to accommodate individuals in a wheelchair. Also, they need to make sure that there are grab bars in all appropriate locations so that if I want to go into this area, but I'm in a wheelchair, that my wheelchair status does not prevent me from going into a specific area or using a specific door or window. Also, it needs to be free of tripping hazards. So they can't make the entire facility um, perfect for someone who's in a wheelchair, but there are hazards everywhere, which would make it very difficult and unsafe for someone using a cane or a crutch to get around. And one of the most important points here, and it just goes to show the depth with which the ADA Act tries to provide full and reasonable accommodation to individuals with a disability or without, is everything should be located on one floor if feasible. So we shouldn't have the bedrooms upstairs and the restrooms downstairs, the activity room downstairs and the cafeteria upstairs. There should be bedrooms and restrooms available on one floor with an activity room available on one floor. It needs to be equal so that it isn't more stressful or strenuous for one person of one disability to get everywhere than someone with or without that disability. Um, so just make sure everything is equal, everything is fair, and everything is fully accessible to everyone. Now, moving on to our second federal law of today, and that's going to be the Civil Rights Act of 1991. Now, the Civil Rights Act of 1991 was actually established as a response to the Civil Rights Act of 1964. And both of these acts sought to provide an opportunity for individuals who found themselves to be the victim of intentional employment discrimination to receive reparations or to uh, get retribution as a result of those discriminations. So specifically, and also to clarify provisions regarding different impact actions and other purposes. But the main purpose of the Civil Rights Act of 1991 was to prohibit all discrimination in employment based on race, gender, color, religious, ethnic considerations, and to establish fairness in the due process for victims who, as I said, wanted to find retribution as a result of the discrimination that they had been through. So, the 1964 Civil Rights Act was the most important civil rights legislation since the Civil War, and many of its provisions are still in effect today. Specifically, the 1964 Civil Rights Act outlawed discrimination in employment based on race, colors, religion, sex, nationality, but it did not permit jury trials for victims of discrimination. So that gave way to the Civil Rights Act of 1991, which is why I said the Civil Rights Act of 1991 largely stems from the Civil Rights Act of 1964, because this was a huge issue that these individuals they set these laws to protect individuals from being discriminated against, but there was no permission in this law for those individuals to seek retribution or take action against those who discriminated against them. So now, thankfully, to the 1991 Civil Rights Act, which set the same precedents as the 1964 Civil Rights Act, Either party may insist upon a jury trial if the plaintiff requests compensatory or punitive damages. So if the plaintiff files a lawsuit, prior to the Civil Rights Act of 1991, this was not possible. The CRA of 1991 also set limits on the damage amount the victim should be entitled to. So not only did they readapt everything that was set forth in the 1964 Civil Rights Act, which was again trying to outlaw discrimination in employment, they went a step further and said, we want to give the victims an opportunity to seek action against those who discriminated against them, and we're going to set limits on how much financial gain they can receive as a result of being victimized due to discrimination. So that was our Civil Rights Act of 1991, which, don't forget, stemmed from the Civil Rights Act of 1964. So our third Civil Rights Act here is going to be the Rehabilitation Act of 1993. The Rehabilitation Act of 1993 is a national law that protects qualified individuals from discrimination based on their disability. Now remember, we defined what a disability was in our first federal law today. The non-discrimination requirements of the law apply specifically to employers and organizations that receive financial assistance from any federal department or agency, from excluding or denying individuals with disabilities an equal opportunity to receive program benefits and services. So, what does all that mean? Simply, the purpose of this act is to ensure that federally funded organizations provide equal opportunity for individuals with disabilities, giving them equal access to activities, benefits, services, and care. It's just establishing equality again for individuals who have a disability. It wants to make sure that everyone had access to the benefits that were being provided. So, under the Rehabilitation Act of 1993, specifically Section 504 protected qualified individuals with disabilities. Now, we defined disabilities already in our previous Americans with Disabilities Act. Remember here, guys, we had 1, 2, and 3. So now that we are in our Rehabilitation Act of 1993, they also want to set their own definition of what a disability was. So let's read it and see if there were any similarities to our ADA Act. So under the Rehabilitation Act of 1993, a disability is defined as a person with a physical or mental impairment which substantially limits one or more major life activities. People who have a history of having a physical or mental impairment that substantially limits one or more major life activities are also covered. So it's pretty much the same definition. That's great. We don't have to review, we don't have to relearn. They just adopted that again. That's great because it's a great definition. So, major life activities, let's see if they define those as the same. So, major life activities include caring for oneself, walking, seeing, hearing, speaking, breathing, working, performing manual tasks, and learning are all major life activities. So, they actually gave us a few more activities as examples. And also in this definition, they went on and defined impairments. So, what are some examples of impairments? Not more or less a disability, but an impairment would include a person with AIDS, alcoholism, blindness, visual impairment, cancer, deafness, hearing impairment, diabetes, drug addiction, heart disease, and mental illness. These are all examples, I'm sorry, of an impairment. Now, the Rehabilitation Act of 1993 specifically prohibited discriminatory acts in healthcare and human services settings. Remember, this act specifically was looking to make sure that all individuals had access to the benefits and the services that were available to society, regardless of their disability status. So, again, Section 504 specifically applies to healthcare and human service settings and set forth that it prohibited against discrimination in organizations which received federal financial assistance. So if your clinic or hospital or long-term facility received any federal assistance, then under the 504, they were specifically impacted by the Rehabilitation Act and still are of 1993. So it prohibited specifically discrimination in service availability, service accessibility, delivery, service employment, administrative activities, and any other responsibilities of the organization. So the Rehabilitation Act of 1993 prohibited discrimination in every aspect of an organization which received federal assistance. Now, let's move on here. A recipient of federal financial assistance may not, on the basis of disability, they cannot deny individuals who are qualified the opportunity to participate in or benefit from federally funded programs, services, or other benefits. They also cannot deny access, services, benefits, or opportunities to participate as a result of a physical barrier. So, again, we talked about this how businesses, health services, they need to make sure that they provide reasonable accommodation for individuals with a physical barrier to participate in the services or programs or reap the benefits and opportunities to participate in those federally funded programs. They can't deny them access simply because of their disability. They need to accommodate that person in order so they can participate in that program. And last but not least, they cannot deny employment opportunities, hiring, promotion, training, or fringe benefits for which an individual may be entitled or qualified for, but because they have a physical disability or an impairment, as we laid out here, they didn't get those services. So, under the Rehabilitation Act of 1993, if you are receiving federal financial assistance, very strict rules. You cannot deny, you must accommodate. And now, our fourth federal act here is going to be the Family and Medical Leave Act of 1993. The Family and Medical Leave Act of 1993 provides certain employees with up to 12 weeks of unpaid job protected leave per year. That sounds amazing. Whoever created this act was a very kind human being, very smart. So, under the FMLA, if you qualify, you receive 12 weeks unpaid job protected leave per year. It's not the best because it's not paid, but still, you have a family emergency, you have a personal emergency. It's good to have that job security that you can leave for 12 weeks, job protected, and come back to your job and still receive health benefits. This is huge. Um, So the specific purpose, what was the purpose? Why did they pass this specific act? Well, the purpose was to help employees balance their work and family responsibilities. It allowed them to take reasonable unpaid leave for certain family and medical reasons. It also helped to accommodate and promote equal employment opportunities for men and women because, as we know, women carry the baby and they have to take a leave that are significantly, sometimes significantly affected uh, health wise, sometimes mental wise as well, by the birth of a baby. It's a huge transition in a woman's life. And sometimes they aren't able to return immediately to their job. So, under the Family and Medical Leave Act, this act leveled the playing field, made it fair for men and women to have equal opportunities, even though, well, taking into consideration that a woman has a baby. So, first thing you are probably asking is, am I eligible? If you've never heard of this act, hopefully you have. But if you haven't, you're definitely asking yourself, am I eligible to take this 12-week leave? I need it. I need it. Well, there are three levels of eligibility for the FMLA. First, criteria that apply to the individual taking leave from their job. Second, there's criteria that applies to the individual who requires care. And there's criteria that apply to to your employer. So there are three levels of criteria that must be met in order for you to be deemed eligible to receive FMLA. So we're going to go over one, two, three, each three categories of criteria that you must meet in order to receive eligibility for FMLA. So first, let's talk about individual requirements. Now, the person taking leave in order to qualify for FMLA must have worked for their FMLA covered employer for a minimum of 12 months. Now, note, even though it says you have to have worked for the employer for 12 months, you don't have to work for 12 months in succession. So back to back to back. The employee only has to have worked for the same employer for a total of 12 months. However, the person taking leave must have worked 1,250 hours during the 12-month period prior to taking leave. This means that if you're working part-time and you have to have averaged 24 hours a week. So you don't have to have worked 12 months in succession. You can't have taken sick time or taken a leave or an absence, what have you. But within the 12-month period, you have to meet a certain hour requirement, which is 1,250 during the last 12-month period before you're eligible to take a leave. So this means if you're part-time, you're averaging 24 hours a week. So I've already done the math for you, 24 hours a week. So the criteria for individuals, of course, we have our work requirement. And then second, we have our time worked requirement. So it's 12 months employed or 1,250 hours total or 24 hours a week for 52 weeks. Those are our individual requirements. And if you meet those requirements, then we can move on to the next category to see if you meet all requirements in order to receive your FMLA leave. So let's carry on. So second here, you see our employer requirements. There are specific employers who can offer you and who are required, to offer you family and medical leave. So employer requirements state only employers with at least 50 employees are required to take part in the FMLA program. Furthermore, the 50 employees are required to work within a 75-mile radius. However, there are exceptions to the 50 employee minimum rule. So, you have to work for a larger 50 employees or more is a larger organization. It can't be a very small self-run business. It has to be 50 employees or more. Then they are required. And you have to work within a 75-mile radius. I'm not sure why anyone would be commuting further than 75 miles, but if you are, then unfortunately, you would not be eligible. And last, there is some hope for you if you don't work for an employer that has 50 employees or more, because there is an exception to this 50 employee minimum rule. And that exception here is bolded in red text, and it states that all schools, as well as federal, state, and local government agencies, are considered to be covered employees, regardless of the number of employees. So if you work for a school, a federal, state, or local government agency, you're covered, regardless of the 50 employee rule. However, the 75-mile radius rule is still in effect. So those are our employer requirements. We talked about our individual requirements of 12, 1250, and 24. And now, last but not least, our care recipient requirements. So we've talked about you as the individual, what qualifies you to receive FMLA. Second, we talked about employer requirements. The person that you're working for, are they eligible to offer this to you? Are they required to? And last but not least, the person that you're going to be caring for, who you need to take this FMLA for, there are requirements that they have to meet in order for you to finally get the check to receive your FMLA leave. And the care recipient requirements are as follows. They must be either the spouse or parent of the individual who wishes to take leave. Certain exceptions exist for adoptive parents and or relatives who cared for an individual as a child. An example would be someone who was raised by their aunt or grandmother will qualify for FMLA. One cannot, however, take leave to care for their mother in law or father in law. The care recipient also must have a serious health condition. So, of course, that leaves it kind of broad. It doesn't go into specifics about what a serious health condition is. This is where you would have to discuss with your employer on what is considered a serious health condition or not, and any stipulations if you were raised by someone else or a relative who's older is living with you and you're the only person who can care for them. This is where it gets so sticky or tricky sometimes. So you have to talk about that with your employer. But if you meet the individual and employer requirements, uh, and the care recipient requirements, then you are qualified to have FMLA leave. Okay, now last but not least will be our Fair Housing Act. The Fair Housing Act. The Federal Fair Housing Act prohibits discrimination in housing, including discrimination against people with disabilities. Of course, we want equality amongst all people, regardless of the disability. The law applies in assisted living facilities and in senior housing. Now, the purpose of this act is to make sure that the sale or rental of any area defined as a residence or dwelling is free from discrimination with consideration of race, color, religion, national origin, sex, familiar status, handicap. It doesn't matter why. Wants to make sure that the sale or rental of any area that's defined as a residence or dwelling is free from any kind of discrimination. And as we said, this specifically applies to assisted living facilities and senior housing. Okay, so what is covered as a dwelling? What is a dwelling? Well, under the Fair Housing Act, they define dwelling as any building, structure, or portions of a building or structure that's occupied or intended for occupancy by a residence. Or residence. So if it's intended to be occupied or used as a residence, whether it's the entire building, a structure of the building, or a room inside the building that's already occupied, it's considered a dwelling. Obvious coverage of houses, apartments, and condos. It includes every kind of residence for any time period, even if it's for a long-term care facility or for a one night for a person as a homeless shelter. They all fall under the rules of the Fair Housing Act. The FHA applies to any multi-unit residential housing that has four or more units. So if it has four or more units, if it's a quadruplex with four, with it's a house with four separate rooms, or a large facility or small facility, if it has four or more units, then it automatically applies to the FHA regardless of its intention to be used. Now, what would be an example of an FHA violation? Well, I did some research, and one of the most common, I turned it into an example here. So, before making an admission decision, a nursing home requires the applicant to disclose a significant portion of his or her medical records. The nursing home applicant, or sometimes the nursing home applicant's family members, presume that the nursing home needs this information to determine if it can meet the applicant's healthcare needs. So they're asking the patient's family or the patient applicant's healthcare needs. What's your health history? Do you take this medication, that medication? Are you able to walk freely? Do you need any supportive or assistive devices? They ask all this information, and the applicant and their family often believe that it's to see if they can meet the healthcare needs of that person. This presumption is wrong. The information is reviewed not by nurses sometimes, but administrators who use this information to calculate the applicant's potential profitability to the facility, which is not correct, which is not appropriate, which is against the Fair Housing Act, because the Fair Housing Act states what? That sale or rental of any area is free from discrimination of any kind, regardless of the handicap of that person. So, again, as we've been talking throughout these federal acts, common themes should be present, and it is not to discriminate, but to accommodate regardless of a person's handicap or disability. So it shouldn't matter what their disability is, because we should be making reasonable accommodations for everyone to provide equal service, equal opportunity, and equal access to benefits. Now, filing a complaint. If you have information about the violation of someone's civil rights, which is a violation of any of the federal laws that we've discussed here, you can contact the Office of Civil Rights. And the hotline number is here. There's a toll-free number, an email, and also a website if you would like to get more information. So you can email, place a phone call, file a complaint, or seek clarification about something that's going on and you're not sure about it, whether it's appropriate or not, and you just want clarification, confidential clarification. Now we reached the end of the presentation, guys. We reached the end, and we're going to do a quick review, 2 questions here, just to test your understanding, just to make sure that you are paying attention and that you took away some knowledge about everything that we talked about today, which I'm sure you did. So the first question that I'm going to pose to you today is, which of the following laws, so we discussed 5 federal laws today, protects an individual's rights to seek retribution for acts of discrimination, among other things, but mostly it protects the individual's rights to seek retribution for acts of discrimination, among other things. So I'll give you a minute here and come back and we'll talk about the right answer. Okay, so hopefully you've made an answer choice here. Let's just read through. So the question was asking, which of the following laws protects an individual's rights to seek retribution for acts of discrimination? So we talked about the Rehabilitation Act of 1993, the Americans with Disabilities Act, the Civil Rights Act of 1991, and the Fair Housing Act. Well, We just talked about the Fair Housing Act. So we know that that has more to do with residence and dwelling. So we can forget about answer choice D. So now we've narrowed it down to answers choice A and B. I'm going to X out answer choice B because answer choice B deals more with specifically individuals with disability, making sure that they are provided with the same opportunity to benefits and service as individuals who uh, do not have a disability. So now we're left with answer choice A and C. Now let's see which one was the right answer. Hopefully you picked one of those two, but I know that of those two, you probably chose answer choice C because you remember that answer choice C, Civil Rights Act of 1991, expanded upon the Civil Rights Act of 1964, which set the precedence for individuals who were victim of discrimination to seek retribution for acts of that discrimination. So, the correct answer for question one was Civil Rights Act of 1991. Let's move on to question number two. This one's a little more difficult, a little tricky, but I'm sure you can get it. The question asks, under which act are all schools as well as federal, state, and local government agencies considered covered employees? Under which act? So is it the Civil Rights Act, the Americans with Disabilities Act, the Fair Housing Act, or the Family Medical Leave Act? I'm going to give you another minute to choose the correct answer, and then we'll be back to review. Okay, so under which act are all schools, federal, state, and local government agencies considered covered employees? Well, Civil Rights Act, Americans with Disabilities Act, Fair Housing Act, Family Medical Leave Act. So, again, we just talked about the Fair Housing Act and we just talked about the Civil Rights Act. So, we know under the Civil Rights Act, it was more concerned with establishing the opportunity for victims of discrimination to seek retribution. So, we're going to cross out answer choice A. And we also know that the Fair Housing Act, as we just talked about for question one, dealt more so with residence and dwelling and defined what a dwelling and a residence was and established the rules for individuals who for any area considered a residence or dwelling for any amount of time, whether it was for a long time under LTAC or one night for a homeless shelter. It establishes the rules of equality and responsibilities. So we can cross our answer choice C because it didn't really discuss agencies or covered employees. So we're left with answer choices B and D. And now of those two answer choices, I know that you chose the correct answer, which was the Family Medical Leave Act. Now, the Family Medical Leave Act, as we talked about, there were three different categories of criteria. It was individual, the person that was receiving care, and the employer. And under those three different areas of criteria, they help you understand whether or not you met the qualifications to receive FMLA. Now, under the individual, well, let's just revisit for clarification. So the Family Medical Leave Act, under employer, we saw that only employers with at least 50 employees were required to take part in the FMLA program. Furthermore, 50 employees are required to work within a 75-mile radius. However, there was an exception to the 50 employee minimum rule. And this is where question two in our quiz came from. All schools, as well as federal, state, and local government agencies, are considered covered employees. So, under which act are all schools, as well as federal, state, and local government agencies, considered covered employees? Under the Family Medical Leave Act. So, that concludes our presentation for today. We covered the Americans with Disabilities Act, the Civil Rights Act of 1991, the Rehabilitation Act of 1993, the Family and Medical Leave Act of 1993, and the Fair Housing Act. We also went through our quiz and we revisited uh, the Family Medical Leave Act, and specifically the rules about the criteria needed for an employer to meet qualification to offer you Family Medical Leave Act. At the end of this presentation, it's my pleasure to say uh, I have spent the last hour with you talking to you about these federal laws and their importance to healthcare and healthcare facilities, as well as healthcare workers like you and I. Again, my name is Deontay J. Marquis. I'm a family nurse practitioner and practicing RN for the past 8 years, um, presenting to you today on behalf of my ALFtraining.com. I want to thank you again for tuning in, for paying attention, and participating. And I hope that from this information today, you were able to uh, you will be able to take some of this information, apply it to your practice, share this knowledge with other coworkers at your facility in your practice, and become a better nurse, healthcare provider, and person within the healthcare field who others can look to. I hope to see you again soon. Presenting again will be me, myself, or one of my other colleagues at myalftraining.com. But until then, I hope you have a good one, and it's been great. Thank you.